Welcome back. Today, students, we have started how partition is effected, which means that what results into partition, what are the causes of partition, and the very first cause which we have seen under the heading of severance of joint status or interest was the expression of intention. The expression of intention is having a very crucial role here. I should note down it. Expression of intention. Okay. So when we talk about the term expression of intention, we have seen that with the help of case laws, the first case was the Pran Nath versus Rajendra case. In this particular case, we have seen that to bring about a severance is a clear and unequivocal expression by words or conduct of an intention to partition should be there. So once a member of joint families agrees for or express certain intention, it results into the severance of status which take place. In the case of Hartyoi Rai versus Shakuntala, in the last lecture, I have told you that once intention to partition is expressed, then further it results in partition and each co-parcel becomes clear, and once it is clear, they hold the property as tenants in common and not, we can say, joint tenants. The tenancy shifts because of this particular intention which happens. Also, I discussed with you the case of Ashutosh versus Vyasaraju. In this particular case, also I told you or I discussed with you that regarding the settled law of severance of a state, how it is affected. It is affected when an unequivocal declaration on the part of one of the joint holders of their intention to hold the state separately is held. Even though when we can say that no actual division take place, but intention is sufficient to act as a, we can say, as a severance of status. Also, I told you that regarding in various cases, the case of Ragha Amma versus Chechana Amma, also in the case of Kamakshi versus Balakrishnan case, in which I told you that the Honorable Court, the Supreme Court of India, have said that there must be intimation, indication, or representation of an intention. So that means that intimation or indication, representation can be by words, by deeds, by writing, whatever. So these are the sufficient things which on which we can say the it will depend upon the circumstances of the each case also. So the cases are there, and each case are having its own facts, and therefore we can say that these facts constitutes to an intention, and therefore they constitute further what we can say that they constitute to severance of a status. So dear students, we were discussing that when we have discussed that the reasons or the motives are irrelevant. The court hasn't given any what we can say relevancy or uh, has not emphasized on the we can say motives and the reasons which are there for partition, that is immaterial, that is of sort we can say family personal choice or family choice, whatever. So these are the things which are not so much relevant when it comes to the court of law. Also, we have discussed that the expression of intention must be conscious. Whenever you are making an intention, it should be you are making it when you are conscious. And if someone is able to prove that it was not conscious act, or rather it was something which was you can say uh, which occurred because of undue influence or certain thing, then it won't amount to partition. Okay, these were the things which I have discussed with you, and also I try to discuss with you the regarding the severance of status, that what is the stand of the Indian Income Tax Act, because the question of severance many a times get complicated when we try up to discuss it in the cases of revenue cases. The joint family makes a fake or what we call it notional partition many a times to avoid the incidence of taxation. Okay, so these are the things which the court tries to check, the courts try to protect, because no law can be inconsistent, no law can be in a contradiction when they are being enforced in a one territory, and they have to serve the purpose what law asks, what law wants. So further, we can say that if this fakeness is given a grasp of reality, nothing probably can be done. But as the Supreme Court has said time and again in many of the judgments, that the expression of intention is mere a preference or a sham, and there are, in the eyes of law, no severance of joint family status. It is something which has been committed or made to avoid the income tax, or just to bypass the income tax law. You're getting it? So these are the, we can say, and also there are many instances in which the co-partners or the people who have tried to create a fakeness of genuineness of a partition, and which by further trying to confuse the court of law. Okay, with the arrangements that a joint family may make for convenience, and fake under the co-partners divide the family or divide the property. So while remaining joint, so such arrangements are, we can say, they do not amount to partition, which we have discussed, and no inference can be drawn further that a partition has taken place. Howsoever long an arrangement may continue, unless it is shown that subsequently co-pastors agreed to partition and apportion of the respective portions of the properties of their possession. So the Supreme Court also have, in the case of Girjanand Nandini versus Vijayendra, the list of the cases were going on. So I haven't penned down this particular, I haven't written or I haven't marked on my PPT. So just for your kind information, I am discussing with you, because there are so many 3, 4, 5, 6, 7, 8, 9 cases already we have discussed by their name in this particular subject of how partition is affected. So again, now we are seeing a different, we can say, instance in which we are trying to analyze that what is the condition or what is the repercussion or when people try to bypass the income tax law. So it is not possible for us to remember, for you also, whenever you are writing for your exam. If suppose you are willing that you are more interested, you can write to me. I will give you the name. But what as a teacher, what I will suggest that these are enough. The cases are enough, and I know that it is not possible for you to remember all the cases. Are you able to get it? Because 8, 9 cases is not only a one topic which you have to cover. It's just a subtopic of your main topic. So in the case of Girja Nandani versus Vijendra, the Supreme Court has said that merely because one member of family severs his relation, there is no presumption that there is a severance between the other members also. Okay, the question whether there is a severance between the other member is one of a fact which has to be determined on the review of all the attendant circumstances. And where there is a severance between the two different branches of a joint family, severance between the members of the branches may not. So, in the absence of expression of an unequivocal intention be inferred. Again, the whole game, the whole, we can say, the story is coming back to the term which is known as the expression of an unequivocal intention. It may be inferred whenever there is an issue regarding the review of attendant circumstances or severance between the two different branches of joint family. So, but if a family consisting of, we can say, several brothers and sons transfer all their assets to a limited company, because now what we are dealing with, you are dealing with something into undivided family, and you will be studying in your 5th semester, as I told you, the Income Tax Act. So when we are dealing with Income Tax Act, as I told you, the things are correlated with each other. One act is related with each other, with other act. And at this juncture, it is not possible for you to read or study everything. You just need to have a bird eye view, just a brief understanding of the subject, that how income tax is also somewhere related to family law. Because the concept of Hindu undivided family, as I told you, have been provided certain privileges, certain deductions or exemptions under the Income Tax Act. So what happened? People are also very shrewd. They know the what we can say the shortcomings, the lacunas, and they try to exploit the situation. They're able to get it. And in the Income Tax Act, further, there are many sources of income. For example, by salary, one can accrue, one can generate income as we people are doing. And the majority of your parents are also are salary employed. The other source is business profession, and you are having under profession, there are so many branches, advocacy is there, medical practice is there, chartered accountancy is there, business is there. Then you are having income from house property, house rent. Then further you are having the other sources such as winning a lottery and so on. And therefore, there is another head which is known as Hindu undivided family, where the parties, people are living together, the Hindus are together. And just to encourage the concept of Hindu undivided family, because there are many reasons. If a Hindu undivided family remains in existence, definitely it will give employment to many people. And if suppose in across a country, if suppose just for an example, there are say 10 lakhs Hindu undivided family. So how how many people that particular undivided family, Hindu undivided family will be giving employment to? This is the question. So that's why the income tax also wants that they should remain in existence. But there are people who tries to create bypass and who tries to create some sort of, or we can say, uh, they want to have some sort of a leeway to generate income or money. What happened? Uh, in many of the cases, the Supreme Court has held that if a family is consisting of, say, in the case of Muraka versus Muraka, MURAKA versus MURAKA, in this particular case, it was held that the family used to consist of 8 brothers and their sons, and they transfer all 8 assets to a limited company. This is another aspect of law. Now, by Hindu undivided family, we are dealing with, just see the beauty of law. We are dealing with concept of family law. The particular concept has been passed to income tax while you are assessing the tax. Now that particular family is trying to convert themselves into a private limited company. You're getting it from family law, income tax to company law. I suppose you will be reading your company law in your 7th or 8th semester, I suppose. So there are different laws which are there. It is a sort of an, we can say, a sort of a, as we are having the celestial bodies, they are revolving around the sun, so that so is the law, so are the laws. There are so many laws which are not even the Civil Procedure Code or Limitation Act, so many. So what the family has done, the family has converted its assets into a limited company, and the 8 brothers and their sons secure equal number of shares in the company, and it amounted to the severance of status. In the case of Muraka versus Muraka, are you able to get it? So these are the things which I'm not laying emphasis, because you are right now dealing with the conceptual part, and that too in your 3rd semester, not even a subject of honors in which I can discuss, not even your dissertation of masters. So I'm just trying to give you a brief understanding of the subject. As I told you time and again, ultimate aim of you people should be to clear the exam. That is the ultimate aim. Because I have seen the people. I have seen the people. There were so many colleagues I have seen who have cleared IIT exam, but they were not able to qualify class 12th. They were not able to qualify. So what is the use of clearing IIT by taking provisional? We can say filling the form provisionally that I am appearing for 12th senior secondary board or senior high school exam. So these are the situations in our country. The short-term aim is we have to clear the exam. And in this particular case, Muraka versus Muraka, which we have seen, what we have discussed here also what happened. the family has converted themselves to a limited company, and court held that it amounts to severance of status. Also, one thing is important apart from expression of intention. The other thing is the communication of intention to the receiver. Though intention to receiver may be expressed in any mode, there is no such bar to the mode. But apart from that thing, the other important thing which we have to see, that whenever there is an intention to receiver, it should be expressed, and it is necessary that the intention to receiver must be communicated to the other co-partners. Are you able to get it? And an uncommunicated expression of an intention at best can amount to desire to partition. It cannot amount to severance. And essential is that the unequivocal communication of intention must be conscious and informed act of the co-partner. The difficult question is there that when should the communication of intention to CBR be deemed effective, and from the date on which the communication is put into the transmission, or from the date which it reaches to the co-partner. So the ancient texts do not throw much light on it, and so in the case of Suraj Narayan versus Iqbal Narayan, it was held that it is essential that the intention must be communicated to the other co-partner. It is a necessary thing that you have to communicate the intention. In another case, the name of the case is Babu Rama Shrey versus Radhika. Babu Rama Shrey, Babu, Babu Rama, Rama, Rama Shrey, Shray, Shrey versus Radhika. In this case, the Privy Council said that the severance may be effective by giving clear and unmistakable intention by his acts, or declaration of a firm intention to become separate. Okay, so there are series of decisions of the various courts which have laid down the severance of status is effective from the date of which communication is put into transmission. When we say that communication of status is effective in the date of which the communication is put into transmission. Also, we have seen the various example under the Indian Contract Act 1872 when the letter or notice or telegram is dispatched. Say it has been dispatched on 24th of September. So the severance of status will take place from 24th of September itself. Okay, there are ample number of cases, Kama versus Meenakshi, Narayana versus Purushottama, and so on. In many cases, it was held that the moment it has been put on communication into transmission, that will become the date for severance of status, and the severance of status will be effected from that particular date. So further, we can say that the intention which has to be considered before the support and the communication of the intention to receiver must be communicated to all interested parties. Okay, so it should be communicated to all interested parties, and which might be received by them on different dates. Their receipt will relate back to the date of notice. And if suppose they are receiving it in different dates, the important issue is that the receipt will relate back to the date of notice, and severance will be effective from the date on which the communication was put into transmission. But this is a subject of, we can say, a next level of proposition, and the court has to interfere in this particular thing because things are bit, we can say, murky whenever they are decided in the basis of transmission and such dates, because it is not so easy, and that's why the vested rights and the rights accrued in the interval between the date of transmission and reserves and receipts are preserved. So this was regarding the communication of effect. As my time is running short, 20 minutes will be over after a few seconds. So I would continue this particular topic, and we will be coming to the next topic of our syllabus, which is the mode of partition. And in brief, we will be discussing it: mode of partition, partition by suit, partition by joint family property, partition by agreement. Okay, these are the few points which I have to discuss with you. Then we will be moving further to the next topic of ours, which is a reunion. So thank you for your patient hearing, all the students, and I hope everything is great at your end. And please take the precautions because even I see that while I was reading the newspaper, the cases are not going down, and what I feel that you people are living in different parts of India, and in many parts of India, the situation is not same. In Chhattisgarh right now in Raipur, we are facing a lockdown which will get over on Monday, and we are facing a lot of inconvenience due to it because grocery is not available and other things are also not there. Somehow, we should hope for the best, and the same thing applies to you also because the cases are growing and vaccine is not there in the market. It's quite difficult to what to say to go out also, even to purchase the commodities for our daily chores, and as the market is totally closed and no one is allowed to move out also. So I suppose in your places things are fine. People are not facing such particular difficulty. The reason why I remain in the campus is because of your recording itself. Because if you're living other parts, what I'm able to get by my other colleagues, they are facing issues in recordings because of the broadband, what we can say, broadband connection, and because of geo and other things. At least I would be able to complete more than the half the syllabus of your midterm. Till midterm, we would be approaching in this week itself because only two topics are left in your syllabus. The reunion is there, which is a good big topic, and I suppose uh, opening of partition is there. So these two topics are left, and then I suppose we would be in a position to complete the course for your midterms. And then succession act is there. Succession act, there are certain we can say principles which I have to discuss with you, and there is no such a big deal in that those things because the cases are less limited, and also we would be dealing after independence. Okay, so after independence, which means post independence issues are there, so they are limited, and then we shall start what to say the Muslim law, and Muslim law also is not a big deal, but I suppose Muslim law we can complete in 10 classes, 10 to 12 classes. It is not a big deal. Gift is there, Hiba is there, succession is there. With some differences of Shia and Sunni law. So, dear students, that is for today. I hope you are keeping and following all the precautions. Take care. Have a nice day. Thank you.